Yes, Mr. Ali.
My lord, I beg to mention item number 5, my lord. My lord, may I pray, my lord, this matter may be taken on the reopening or 19th, any other date may be fixed, my lord, if lordship desires.
What do you order? Let the matter is.
My, my lord.
My lords, I beg to mention there's two items. They filed it on Saturday only. They have the filing number. So it may be taken up tomorrow.
We have filed it on Saturday.
Yes, my lords.
FT matters.
Yes, ma'am. There's some urgency. The person is in detention, my lords. The person is in detention.
Since when?
It's been 4 months. 4 months.
4 weeks,
4 months.
4 months. So what is the urgency?
No, man, so we have, there's a review petition. So it has already been displeased by this honorable court.
Only after you cure any defects, if any.
My topics. Please, your lordship. Lordship, I beg to mention it. Item number 8 and item number 9, your lordship.
For what?
For adjournment, your lordship.
Why?
Mr. Counsel, Mr. Aswar has some difficulty today, your lordship. If possible, your lordship. Any?
Let the matter is.
Obliged, your
Please, your lordship. I will come to item number 3, my lord. Kindly adjourn for that. On behalf of FSN, who is out
What
of
is the
session.
difficulty? What is the difficulty?
On behalf of FSN, he is now out of session, my lord.
See, let the matter is.
May I please, your lordship, I beg to mention item number 18. Kindly listed after beautification.
What's your good name?
A. Parasar,
You are appearing on whose behalf?
Ardhar.
Right.
Yes.
Yes.
Please, Roshan, I beg to mention item number 21 of the reviews. Our conducting counsel is out of station, lordship, so matter may be taken another day, your lordship. His name reflected in the advocate leaves note, your lordship.
Who is absent?
Uh,
Who is the concerned counsel?
A.W. Aman, lordship.
Appearing for whom? Item number 20.
No, 21, lordship. Shamsher Ali. Deeply obliged, lordship.
Very good. Very good.
Take your seat. Take your seat, Mr. Sharma. Yes, Mr. Sharma, what is your conflict?
My lord, at this stage, my immediate prayer is, my lord, WS was filed, document was annexed. Only exhibition was not done. This is the fault from the side of petitioner. And due to that, my lord, from the prolonged suffering from cancer of the council who is conducting the case, that was not done. And my lord, petitioner before your lordship is a fisherman and illiterate one.
That is not the issue here. First of all, you have been considered as a deputy, right? Then proceeding was executed against you. You received the notice. And then after taking long days, you have filed your reply. Because initially the tribunal decided to proceed with expertise. You have filed an explication, set aside that expertise order and for submission of written reply, which was allowed by the tribunal. Accordingly, you have filed your reply along with the documents.
Well, after filing of WS, my lord, that is, my lord. But not exhibiting the document, that is why, my lord, that order has been passed against me,
6th of March 2008, as per the record.
my lord. My lord. Long gap is there, my
You have
lord,
received notice.
due to prolonged suffering from
Listen,
cancer of the council, and he is,
That
my
is
lord,
not the issue, Mr.
illiterate,
Sharma. That is not the
illiterate
issue.
fisherman, my lord. He feel that this case is going on,
It cannot be, you have to appear, there was nothing like that.
but
No
without
order has been
instruction from the council, my lord, he is nothing, anything. Otherwise, my lord,
Now-
he is cooperating. Only prayer, my lord, I may be allowed to exhibit the document. Except that if I am not able to satisfy the learned tribunal, then that will be, that order
There
will
is
be
certain
passed, my lord.
reasons
Only
behind
prayer, my lord, only prayer.
See, Mr. Sharma, the notice you have received when? Are you aware? When did you receive notice?
That was signed, my lord, 5/10/06.
So
Notice was,
from 2006, after receipt of the notice, when did you enter reference?
my lord, WS was filed on 2/9/2008.
Hmm.
And only thereafter, my lord, so many days was adjourned. But
It was not adjourned.
sometimes, my lord, petition was filed by the council. And due to as per document, my lord, my father is a voter of 1966. All documents with me, but at the relevant time, my lord, that was not exhibited. And that is why that order was passed against me. And in our judgment also that has been reflected.
You are aware since 2006 that there was a proceeding of pending before the tribunal. Of your own, you have filed your reply
My lord, on,
on 2/9/2008.
my lord,
And thereafter, you remain silent. And
only my lord, one
your name
opportunity.
was not reflected in the NRC, draft NRC.
My lord,
You came to know then.
my lord. Other family members' name is there, my lord. My
And
father,
thereafter,
mother, and my
that's
brother
not
also.
final, that's not
Only
final.
my name is not there.
Thereafter, you approached for the certified copy of the order.
My lord,
You approached the certified copy of the order. And record reveals that you applied on third of August 2019, which you have received on 8th of August 2019. It's very clear from the record.
keep the power. Well, my lord.
And you filed this writ petition on
4/9,
4th of September.
my lord.
From the order sheet, let Mr. Sharma read the order sheet and tell us is there any sufficient reason to consider your
My lord, if that order is not set aside, my lord, my family members will be here and I will be in.
you read?
25/9/2006 অসম চৰকাৰৰ জাননী নং PLB 101/2005 PT 194 দিনাংক 2/2/2006 আৰু PLB 101/2005 PT 226 দিনাংক 5/7/2006 মৰ্মে বিদেশী ন্যায়াধিকৰণ নগাঁৱৰ পৰা গোচৰ বদলি সূত্ৰে পোৱা গ'ল পঞ্জীয়ন কৰা হওক অহা 20/10/2006 তাৰিখে অপৰ পক্ষই এই ন্যায়াধিকৰণত হাজিৰ হৈ লিখিত জবাব দাখিল কৰিবৰ বাবে জাননী দিয়া হওক ধাৰ্য 20/10/2006 তাৰিখ হাজিৰ ও জবাব দাখিল কৰিবৰ বাবে 20/10/2006 চৰকাৰ পক্ষ হাজিৰ নাই অপৰ পক্ষৰ জাননী চীনা জমিত ঘূৰিছে গাঁও কচুৱাবৰী থানা জাগিৰোড ঠিকনাত নকৈ নটিচ প্ৰেৰণ কৰিব ধাৰ্য 5/12/2006 তাৰিখ নটিচ জাৰিৰ বাবে 5/12/2006 চৰকাৰ পক্ষ হাজিৰ নাই অপৰ পক্ষৰ বিৰুদ্ধে যোৱা নটিচৰ হুকুম মতে
Sorry.
After 20th of
Haji Roy
October
দেখা না যায়।
2006, what is the next date fixed?
16/1/2007.
After 2006.
For experience.
Okay. Then Lordship 16/1/2007 Lordship.
What is the
Yeah,
order?
On 16/1, they have final.
সরকার একটু হাজির নেই
হুম।
আবেদন
অপরপক্ষ
405 নম্বর
16/1 appears. 16/1 first appear. Documents করার পরে সময়
সরকার হাজির নাই
Yes,
সরকার হাজির নাই সরকার হাজির নাই
on Lordship 16/1/2007, he first time appeared to his council Lordship,
file petition
filed petition and
granted time.
accordingly granted time for filing WS.
Next date.
Then Lordship 5/3/2007, on that day Lordship,
Petition
same petition filed Lordship,
Time taken.
taken Lordship.
Then
And then Lordship 21/4/7, again time taken Lordship. Then Lordship 18/6/7,
8/6.
18 Lordship 18/6/2007, সরকার পক্ষ হাজির নাই, অপর পক্ষ আপত্তি,
বাতিল করা নাই নি?
yes Lordship,
পুনর্নেতা
yes Lordship, again they
একজন নাই।
wait for time.
prayed for time Lordship. 18/6/2007. Then Lordship 23/8/2007, বিনা তদবিরে গড় হাজির মানে কি?
পুনর্নেতা শেষ হয়ে গেল।
Yes Lordship.
Again,
Again, 23/8/2007, last chance has been given Lordship.
To file reply.
File written statement Lordship. Then Lordship on 28/11/2007, on that day also they did not file Lordship, WS and
Expert
and Lordship,
expertise.
শুনানি রোড
Expertly order.
yes Lordship, fixed for expertise order Lordship.
শুনানির বদলে শুনানির বদলে
Expertise শুনানির বাবে কার্য করা।
Expertise
Proceed
শুনানি।
expertly.
Yes
Proceed
Lordship.
expert.
To
Proceed expertly.
Yes.
Then
Expertise শুনানি দেব।
Then Lordship 6/3/2008.
মুখ্য বাহিৰত
On that day also,
PO is on leave.
yes Lordship, PO is on leave, but on that day also petitioner was not present.
Then
And then Lordship 10/6/2008 Lordship.
PO জানো
Yes Lordship. Again Lordship,
ভেরিফাইং অফিসার not present.
date was fixed for expertise hearing Lordship.
PO was not present.
Then Lordship 2/9/2008.
application file
Yes Lordship.
and
জবাব
also the
দাখিল
reply
করছে।
file.
Yes Lordship.
জবাব দাখিল করছে।
বছৰৰ লগত হাজিৰ তিনি
Then for the witness,
দাখিল
it was accepted by the tribunal
Yes Lordship.
and the fixed for witness.
Yes Lordship. Then 22/10/2008 Lordship. অপর পক্ষ হাজির, সাক্ষীৰ সমন ৰীতিমতে জাৰি হোৱা দেখা নাযায়, এই ভিঅজনক নকৈ সমন কৰা হওক ধাৰ্য তাৰিখ শুনানিৰ বাবে। Then Lordship 5/2/2009.
What happened? Notice been served on the witness.
লৰ্ডশ্বিপ অপৰপক্ষ হাজিৰ হৈ 109 নং দৰখাস্ত যোগে অন্য এটি দিন ধাৰ্য কৰিবলৈ প্ৰাৰ্থনা জনাইছে। চোৱা হ'ল ভিঅ'জনে অন্য এটা দিন ধাৰ্য কৰিবলৈ প্ৰাৰ্থনা জনাইছে। ভিঅ'জনক পুনৰ চমন কৰা হওক।
Then
ধাৰ্য 5/5/2009 তাৰিখ ভিঅ'ৰ বাবে।
then
দেন 5/5/2009 অপৰপক্ষ হাজিৰ ভিঅ'জন অহা নাই। ভিঅ'জনক নকৈ চমন দিয়া হওক। ধাৰ্য 8/9/2009 তাৰিখ ভিঅ'ৰ বাবে। দেন 8/9/2009 অপৰপক্ষ বিনা
হাজিৰে
নহয়
Bina Arjire. Bina Arjit, I think.
বিনা আৰ্জিৰে
গড়
গড়
Arjit nine.
প্ৰিয়জনৰ অসুস্থ বুলি
গড় হাজিৰ নাই। ভিঅ'জনৰ অসুস্থ বুলি জনাই দৰখাস্ত যোগে সময় বিচাৰিছে।
Then
দেন ধাৰ্য 1/10/2009 দেন লৰ্ডশ্বিপ 1/10/2009 অপৰপক্ষ
or Hajir.
বিনা আৰ্জিৰে হাজিৰ ভিঅ'জনৰ চমন ঘূৰা নাই। পুনৰ চমন প্ৰেৰণ কৰা হওক। ধাৰ্য 19/3/2010 তাৰিখ ভিঅ'ৰ বাবে। এণ্ড 19/3/2010 লৰ্ডশ্বিপ অপৰপক্ষ
Now, after 110, what is the next day?
আফটাৰ 110 19/3 লৰ্ডশ্বিপ
2010.
19/3/2010 lordship after 2 months lordship
Huh.
no
After
after
110, after more than 4
4 months more than 4 months lordship then lordship after 19/3 it was fixed for 2/7/2010
I think so. On 19/3, member came. I think.
yes lordship on 19/3 view came lordship
His evidence was taken.
this evidence was taken on that day. I think it will be okay.
He was a witness to the proceeding.
Yes, lordship. That is a BOA. And then lordship 2/7/2010 BOA 3/4 নং দৰখাস্ত যোগে হাজিৰ হৈ জান then lordship on 2/7/2010 again they seeks for adjournment lordship
Whether the proceeding or the witness.
BO lord
You is qualification of which?
Yes,
Whether the petitioner appeared,
not mentioned.
not mentioned lordship
then
on that day.
directed for evidence of the opposite party. On that day, it was directed for the evidence for the opposite party. 27.
Then lordship 23/7/2010
ডাক্তৰী প্ৰমাণ পত্ৰ
অপৰপক্ষৰ অসুখ বুলি জনাই BOA 458 নং দৰখাস্ত যোগে
You did not appear.
yes lordship
You stop for time.
yes lordship then lordship fixed for 5/8/2010 lordship
Evidence for.
and it was fixed for evidence for opposite party lord then lordship সদস্য মহোদয়
Out of proceeding out of state.
মুখ্য কাৰ্যালয়ৰ পৰা yes lordship
BU
then lordship presiding officer was out of station on that day 5/8/2010 lordship BOA 498 দৰখাস্ত যোগে পক্ষগণ আহিব নোৱাৰাৰ বাবে কাৰণ দৰ্শাই মুলতুবি বিচাৰিছে ধাৰ্য 25/10/2000 তাৰিখ দ্বিতীয় পক্ষৰ সাক্ষীৰ বাবে then lordship 25/10/2010 on that day
হাজিৰ নাই
পক্ষতে হাজিৰ নাই both the parties are absent on that day lordship again given chance for filing evidence lordship then lordship it was fixed on 3/12/2010 again, they
Absent.
file, yes, Lordship, for illness, file adjournment petition, Lordship.
BO,
BO মানে
by the BO.
BOA, BO মানে কোন?
BO মানে
Verification officer,
Verification.
BO
you're supposed to give evidence,
Yes,
then
Lordship. Then Lordship, next date was fixed on 8/2/2011. বিপরীত পক্ষৰ অধিবক্তাই 90
এইটো বিপৰীত পক্ষৰ অধিবক্তাই
Hmm?
ডিঅ মিনছ মেলত বিপৰীত পক্ষৰ অধিবক্তা নট ডিঅ
E or BO.
BO.
BO,
বিপৰীত
Yeah.
পক্ষৰ অধিবক্তাই
After 3/12/2010, Lordship, it was fixed on 8/2/2011.
Hmm.
Again, Lordship,
বিপৰীত পক্ষৰ অধিবক্তাই
proceed fixed for adjournment and it was fixed. Hmm?
ঘৰত সৰস্বতী পূজা
On the occasion of Saraswati Puja, Lordship.
then what happened?
Then, Lordship, it was again fixed on 8/4/2011, Lordship. বিনা আজিৰ পূৰ্বৰ হুকুম চোৱা হ'ল অপৰত পক্ষই বিবেচনা কৰি গোচৰ তৰ্কৰ বাবে yes, Lord. On 8/4/2011, Lordship, a tribunal discard fix the matter for argument, Lordship. Then, Lordship, 28/4/2011,
বিপৰীত পক্ষৰ অধিবক্তা আজিও
অপৰিত
বিনা আৰ্জিৰে গড় হাজিৰ
Hmm.
বিনা আৰ্জিৰে
অপৰ পক্ষৰ অধিবক্তা বিনা আৰ্জিৰে গড় হাজিৰ পূৰ্বৰ হুকুম চোৱা হ'ল ধাৰ্য 30/4/2011 নথি ৰায়ৰ বাবে। Then, Lordship, 30/4/2011, অপৰ পক্ষক গড় হাজিৰ ৰায় বেলেগে প্ৰস্তুত কৰি
Kindly read the order of 28 April.
20
অপৰ পক্ষ আজিও বিনা আৰ্জিৰে গড় হাজিৰ
Hmm.
পূৰ্বৰ হুকুম চোৱা হ'ল ধাৰ্য 30/4/2011 নথি ৰায়ৰ বাবে।
Hmm.
Then, Lordship, 30/4/2011, অপৰ পক্ষ গড় হাজিৰ ৰায় বেলেগে প্ৰস্তুত কৰি নথিৰ লগত ৰখা হ'ল দ্বিতীয় পক্ষক বিদেশী আইন 1946 2 ক ধাৰাৰ অধীনত বিদেশী ঘোষণা কৰা হ'ল অসমৰ ভোটাৰ তালিকাত তেওঁৰ নাম সন্নিৱিষ্ট থাকিলে তৎকালীনভাৱে বিধিমতে কৰ্তন কৰা হওক ৰায়ৰ নকল সংশ্লিষ্ট কৰ্তৃপক্ষলৈ প্ৰেৰণ কৰা হওক। Then, Hmm? কিবা সুধি আছে পাৰিলে দেখোন সদায় প্ৰেজেণ্ট আছিলে কেঞ্চাৰ ক'ত আছিলে নাই ডকুমেণ্ট দিয়া নাই ডকুমেণ্ট দিয়া নাই 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 দিয়া নাই এখন সার্টিফাইড কপি নহয় নেকি?
Eight to 21 advocate develop solver. 8 to 20 lang na first.
দাদা
উপস্থিত করে
বহুদিন হেৰি কিনো বহুত
In record lordship, there is nowhere mentioned lordship that concerned advocate is suffering from cancer or any illness lordship.
No, the counsel for the petitioner expired sometime in 2016.
Lordship.
The order was passed in 2011.
2011 lordship. And each and every day lordship, advocate of the proceeding has been appearing lordship. Appearing lordship.
Yes, pass on the record.
বিপরীত পক্ষৰ
In 97, my lord, did not, SD voter. my lord. Page 4, page 14, my lord. Typography and original copy is 15. Serial number 31693, number 498, Niragul Sarkar, Father Pores. I have to that, my lord. That was not with me, my lord. That is my lord. Of 27 years, my lord. 27. So, well, that is not with me, my lord. My lord. That was not. My lord, only my lord, limited prayer, my lord. All documents is, my lord, and the record reflects also that my 66 voter, 60, my lord, 1966 voter list is in the record, my lord. My father is there. My wife, my lord, my brother, other family members' name is there. The order has been passed as per due process, my lord, but from the part of the petitioner, the petitioner is a fisherman and illiterate one. So after giving the file to an advocate, he believed that the case is going in properly. But while, my lord, for set aside the order, my lord. My lord, my father is Indian since 1966. My father is casting vote, and I am in. I am born in the year 1970. So my lord, that is pronounced as per my lord procedure, my lord, due to my lord, enough from my part that documents was not exhibit. So that is why before this honorable court for one opportunity.
or that is maintained under the law.
The lordship may direct, considering the fact.
Under the law, it is that can be considered.
Having sufficient document but not able to produce at relevant time. That is, my lord, before this honorable lord, the court has discretion to do that, my lord.
To be considered.
My lord, some time may be given and I will try. Not that, my lord. Next week, my lord. One last chance, my lord. Because there he has not got chance now. My lord, opportunity is given, my lord.
What was the time
My lord.
after evening time?
My lord. My lord. My lord. My lord. Well, that meant. My lord. The opportunity was given, my lord, but that was not availed. But this is not known to me. And after that is why, my lord, my limited prayer was only to exhibit the document to satisfy the court. Obviously.
Yes, Nebula Lordship, my lord. Lordship will kindly turn to my lord page 77 is the impugn order, my lord. My lord. My lord. School transfer certificate, my lord. The school transfer certificate. It is the link document, my lord. Page 27, my lord. Connection. Yes, my lord. That is the, my lord, voter list of 1965. My grandfather's name appeared. Page 29, my lord. Ahmad Ali. Yes. Sorry. Father's name appeared, my lord, in page 33, voter list of 1985, my lord. A. Rashid. That is, my lord, from Ural Kata village. It is wrongly written as Ural Kati Potham. My lord. Father, he is from adjacent village, so Porusala, my lord. In the voter list of 1985, my lord, the father's name appeared, and when then he was 34 years old. My lord. In the adjacent village. Definitely. Yes, my lord. By exhibiting the, my lord. Yes, my lord. Yes, my lord. That the father of the proceeding has been also born and brought up at the same village, Forusala, and he has been residing at the same address with his family till today. My lord. Fathers of the proceed, he has two brothers, Abdul Rashid, the father self, and Abdul Majid. All are residing at their place of birth at Forusala under the same. Yes, ma'am. Yes, my lord. After 70, my lord, that should have been, my lord, explained in the WS, my lord. That is not explained in the WS, my lord, but my lord, regarding the, my lord, the exhibit, my lord, Q, my lord, the another order, my lord, through which, my lord, the father of the, my lord, proceeding was declared to be a not foreigner, my lord. My lord. Some other documents. Yes, my lord, that should have been, my lord. That should have been explained, my lord, in the WS. That was not explained, my lord. I admit that. But regarding the, my lord, linkage and other documents, my lord, the exhibit Q. That is why the, my lord, the deposition of the, my lord, father as well as the, my lord, the school headmistress, my lord, regarding the school transfer certificate. My lord. Yes, my lord. Panchayat secretary certificate. 27 is the school transfer certificate. It was issued on, my lord, the date is not, my lord, legible, my lord. The same way, my lord, the certificate copy was obtained, my lord. It should 11/8/2018, my lord. 11/8/2018, my lord. Yes, my lord. In the year 1989, my lord. 31/12/1918. Well, for the first time, the name of the petitioner was figured in the voter list in the year 2005 only. 5, my lord. Then she was 28 years old from her matrimonial house, my lord. Another village, my lord, Kolmawadi, along with her husband. My lord. She was. Yes, my lord. Yes, another village. Kolmawadi. This is the voter list of 2005, my lord. 28 years old. And she should have been, my lord, eligible to vote, my lord, probably in the year 1995, my lord. She should have been. 27. Yes. Date of birth. My lord. Well, when it was after 29 years. Actually, my lord, when it was required to be placed before the concerned tribunal, my lord, then only she had obtained, my lord, this certificate. That was a part of record, my lord, in before concerned tribunal. My lord. That was not necessary. That is why, my lord. It was exhibited, exhibit P, my lord. Page 55 is, my lord, the serial number 27. The grandfather's name, my lord, appeared, my lord, serial number 22, my lord. page 55 in the vernacular, my lord. Serial number 22, my lord, Ahmad Ali, my lord. The left side, my lord. Grandfather of the Prasidi, my lord. Appeared, my lord. Horuswala, my lord. From that village, my lord. My lord, earlier, my lord, in the voter list of 1965 and 70, my lord, his name was reflected from the adjacent village, another village, Uralkata, my lord. But in the land Jamabandi document, my lord, the grandfather's name appeared. Grandfather name was, my lord, was stated as Ahmad Ali, my lord, son of Sulman. Well, in the 65 voter list, only Sulman is there. In the 70 also, my lord, Sulman, my lord. Sube Ali, my lord. Again, it was wrongly written. My lord. Yes, my lord, that the Prasidi has 5 sisters and 1 brother, namely Jusnara Begum, aged about 44 years, Hasnara Begum, aged about 40 years. Afia Khatun, aged about 36 years, Husnara Begum, aged about 33 years, Sufia Begum, aged about 27 years. Jahirul Islam, aged about 24 years. My lord. 70 is the vernacular, my lord, deposition of in cross, my lord. Yes, my lord. I am born, it is wrongly written, my lord, type. Born at Horosala under Moirabari place. I have 2 brothers, Fakhruddin Islam, who expired in 2008, and Jainal Islam. I also have 4 sisters, Jusnara, Afia, Husna, Safia. Jusnara is the elder among all of us, eldest. I have 1 paternal uncle, namely Abdul Majid, who is settled. It is not legible, my lord. Another, Ahmed Ali. Some of the lines, my lord, these are not legible, my lord, illegible. Both father and mother are custodied separately at Orosal. I got married in 1998, the last line, my lord. So the other sisters are there only, my lord, while preparing the, my lord, WS, my lord. Another brother, his name also should have been reflected in the, my lord, WS, my lord. That is Fakhruddin, my lord. These are prepared so casually, my lord, by the councils in the tribunal, my lord. That is my lord. Some wrong has occurred, my lord. Holidays. She may join the school on 25th of December, but she became headmistress in April 7. Don't grow for it. Don't grow for it. Office to one more time, that is her work. My lord, may I pray before your lordship, my lord? For a moment, my lord, lordship will kindly come to page 82, my lord. How it relates to page 82, my lord. How it relates to my case, my lord. My lord, kindly have a look at para number 3, my lord. Number 4 para. The DW1 O.P. Abdul Rashid has stated in his deposition that the name of his father, late Ahmed Ali, and he was born at village Ural Kata, my lord. That was rightly demonstrated during the course of his trial, my lord. And unfortunately, my lord, while discharging my burden, my counsel, my lord, reflected it wrongly, my lord, in the WS. And regarding other documents also, my lord, same set of documents were placed by name and by identity, my lord. It is absolutely identical, my lord. And the O.P. Abdul Rashid has produced and exhibited some documents in support of his Indian nationality as follows. Exhibit A is a certificate issued by Gaubura village, Khorosola, certifying that OP has been residing at village Khorosola. Exhibit B is a certificate issued by the Gaubura village, Khorosola, certifying it to be true that one of the OPs named Fakhruddin has died. And the petitioner has also, my lord, named this her brother Fakhruddin, that he is also no more, my lord. Exhibit G is a certified voter list of 1965 containing the name of Ahmed Ali, whom OP has named as his father. Exhibit H is a certified voter list of 1970 containing the name of Ahmed Ali, son of Sulman, whom OP number 1 has projected as his father. Exhibit I is a certified voter list of 1985 containing the name of OP number 1, Muhammad A. Rashid, son of Ahmed Ali, as the voter of village Khorosola, PS Lahorihat. Exhibit J is a certified voter list of 2005 containing the name of OP number 1, Muhammad A. Rashid, son of Ahmad Ali, as voter of village Khorosola, PS Lahorihat. Exhibit K is a certified voter list of 2010 containing the name of OP1 as voter of village Khorosola, PS Lahorihat. Exhibit L is a certified voter list of 2015 containing the name of OP as voter of village Khorosola under PS Lahorihat. Exhibit M is a computerized copy of Jamabandi containing the name of OP's father, but of which year did the particular plot of land was bought by OP's father cannot be ascertained, so it is not accepted. Now, if your lordship kindly turn to next page, my lord, page 84, my lord. The second paragraph. I have gone through the entire case record and verified all the exhibits that have been submitted by the OPs in connection with their Indian nationality very carefully. I have gone through the other depositions of DW3 named Noor Muhammad, the purported brother of OP2, DW4, the headmistress of Khorosola LP School, and DW6, Gaubura of Khorosola Gau, very minutely. After observation of all these things, I find that OP number 1, Abdul Rashid, son of late Ahmed Ali, and his son, Jahirul Islam. He was also named by the petitioner during the deposition, my lord. That Jahirul Islam is the brother of the petitioner in my case. Both are resident of village Khorosola, PS Moirabari, district Moregaon, Assam, are genuine Indian citizens, and as such, they are declared as Indian citizens. My father was declared to be Indian citizens, and the reference was answered negative in respect of my father, my lord, in his case, my lord. Therefore, my lord, my humble prayer, my lord, before your lordship, my lord, lordship will kindly call for the record, my lord. In the meantime, I may kindly be protected, my lord. And yes, my lord, some mistake has occurred on the part of my earlier counsel while demonstrating my case and submitting my WS. Just very minor mistake that I admit.
That is not a minor mistake, my lord. He has stated that his father was born in the Sorusola village, which cannot be. And there is no statement to the effect that their grandparents were residing in there. There is not a single whisper in the WS about the grandparents.
Yes, that should have been.
Not a single whisper that grandparents were residing in some other village. And they have shifted somehow or sometime. It's direct statement that his father was born in Sorosula village, which cannot be.
My lord, that should have been made, my lord, but the
Not, it is
documents
not
which
should have
were
been
placed
made.
before the, my lord, two tribunals, my lord, same set of documents were
All
placed.
these are contradictory.
Same documents. My lord, will kindly compare the documents.
That is
The
in
name,
fact,
the
that will not-
identity, everything is identical.
The second judgment will not assist, my lord, because it's of a different persons. First of all, he has to link himself to those persons, my lord. Not a single whisper about grandparents, their place of residence, their time of death. These are important parts.
My lord, the record speaks about the, my lord, the identity and the residential status of the grandfather, but it should
Records
have
can
been
be of
made,
different person.
my lord, it should have been
Without,
explained in the
without
WS.
giving
that I
any
admit.
statement, how can we accept that that is of that person, that person, that records are belong to that person? He has not stated any. He has not stated anything about the grandparents. In fact, from record, it reveals there are two persons in two villages in the same name, my lord. The record reveals, my lord, the voter list of 65, 66 reveals one Ahmed Ali, son of Suleiman, was there in some other village, my lord. Then Ural Katha Pathar in 1966 and 75. This is one Ahmed Ali. And the Jamabandi copy reveals another Ahmed Ali in Sorusola village, that is whose father name is different. So my understanding is what from the record, if I say, my lord, from the record, it reveals that the grandfather of this petitioner is Muhammad Ali, whose father was Sube Ali, who was a resident of Sorusula village. And it is right, the grandfather have died, the father was born in Sorusula village. That could be the. But his father is not of this, my lord, Ural Katha Pathar. The record reveals that without any statement, that no, I'm not, I'm the grandson of that person, not of this person. How can we accept it? If we go to the records, there are two persons in the two villages in the same name, and the the father names are different. So these are different
Grandfather's name was
persons.
wrongly reflected in the Jamamandi.
Not, how can we say it is wrongly
Yes,
reflected?
but
Can you say
at least one
who has
statement
given
should
this
have been made in
statement?
the WS.
Who has given this statement that this is a wrongly
Should
recorded?
have been made regarding the state.
Is it
identity of
corrected by
grandfather.
someone else? Is it corrected thereafter? If it is corrected by an application, it's okay. Who has corrected? Never he has claimed that this name has been wrongly reflected. This Ahmad Ali, son of
I'm praying before your lordship, my lord, just to compare the, my lord, both the documents which were placed before the two tribunals. My lord. Thereafter, my lordship will find the linkage and lineage. Everything will be established. My lord. Yes, my lord, regarding the status and the identity of the grandfather, at least, my lord, something should have been made in the WS, my lord. That was not demonstrated, my lord. By
it
the
is
council.
the WS
That I
on the
admit.
basis of which he has to prove his case. He has not stated anything in the WS. Now, on the basis of some other judgment, he is claiming
No,
benefit.
this man has also deposited before the concerned tribunal. The deposition of father is also there, my lord, page 72 and extra 14. My lord.
In fact, father also deposed. He was born and brought up in Horusola village. And the very first line he has says, Yes. Yes. Yes, ma'am. Yes. Yes. Suleiman. Modoniato, my lord. Yes. Mm. Bisicois bison taste. In place of my lord, serial number. Mm. Yes, ma'am. Yes, ma'am. Again, ma'am. That's fine, ma'am. That's a little bit. I just.
Or she may pray for interim, my lord.
My lord, interim may be granted. that unfortunately in between 1983 to 1986, father of the opposite party, namely Alimuddin and mother Nurjahan, died out of their old age. দেউতা মৃত্যু হোৱাত 50 বছৰ হ'ল। দেউতা 1711 total 58.
Nineteen 1966.
দে- 50 বছৰ হ'ল। দেউতা মৃত্যু হওঁতে মোৰ বয়স 30 বছৰ আছিলে। মোৰ মাৰ নাম নুৰজাহান। মা বৰ্তমান জীৱিত। মোৰ ভাই ককাই 6জন। Yes. That unfortunately in between 1983 to 1986, father of the opposite party, namely Alimuddin and mother Nurjahan, died out of their old age. Obliged. My lord, interim order may be granted.
My lord. My lord, here in this case, this writ petition is filed second time, my lord. In the first round of the, my lord, remanded back, tribunal did not accepted the evidence of brother because brother's name is not mentioned in the WS. That was the reason taken by the landed tribunal. This whole court has held that that is wrong, that is devoid of law, and the reason is not correct, and demanded the matter. The tribunal again, the same thing, my lord. Same discussion that brother's name is not in the WS, so his evidence not acceptable, my lord. My lord, the impugned order, the page 60 in paragraph 62, my lord, the relevant portion on page 62, last 3 lines of first paragraph. But she has adduced evidence of this witness during the time of evidence without mentioning him in her WS, in her written statement. As such, this plea cannot be taken in favor of the proceeding in any way. My lord, is it not a contemptuous, my lord? This honorable court has specifically said the non-mentioning of the brother's name in the WS cannot be taken a ground to disbelieve the evidence. That has been clearly stated in paragraph 5. Of the judgment, my lord, the High Court judgment, my lord. Grandparents are voter in 1965. Parents are voter in 1971. My lord, the brother who was examined, he is also voter with parents.
Mhm.
দিয়া নাই এখানে দেখো ভিতরে হুম
My lord. My lord, cross part is not given to us, my lord. That record may be called for, my lord. That will be best, my lord. Coincidentally. Not very good. That's a cross. Or game. Lord, total list also nine. I will be administering. Grandfather's name is Abdul Sheikh. Naib Ali is Nis Ali, Ali, Haraz Ali. My lord. My lord, Annexer 12, my lord, this opinion, judgment of this honorable court, page 56. My lord, may I prefer interim, my lord, women, my lord. My lord. My lord. Yes.
Yes, my lord. Yes. 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 Legas others. Yes. 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 Only one. Yes. 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 No, let me examine that one, that judgment. It is not coming to my mind. Yes.
Lordship.
Yes. Copy of it.
Lordship.
Yes. Yes.
Without.
Yes. Yes. Yes, sir.
Lordship.
Yes, good. Yes. Minority party. Yes. And only that, my lord, they are still, my lord, due to this, my lord, case. They are kept in devoters. Hmm? Yes. This is good. Yes. Why is it? Thank you, thank you, thank you. 2000.
2019 1 GLT 353.
353, no? 63.
3531 and 360 is the.
Same judgment, Lordship.
Oh,
Both are same judgment, Lordship.
In Subi
Oh.
Road, there's another one also is same.
Same judgment, Lordship. Same.
what is that question?
Twicely reported, Lordship.
Okay, so.
Lordship.
Yes. So in that way, the medical lordship one, then dispose of. They take a my lord on 20. Yes. My lord, let it one 23 or 22, any date, your lordship's convenience.
Lordship.
Habla, your lord, deeply habla.
Thank you.
Thank you.
May I please your lordships? My lord, as per last order of this honorable court, 28-3, I have taken steps, lordship. No, not 28-3. As per last order dated 18-3-2024, I have taken steps with regard to respondent number 2 and 4, lordship. And it's also reflected in office note dated 28-3, lordship. Respondent number 3. B. Soren. Your lordship, I'm appearing on behalf of BD Paul, my senior counsel. No one appear again. I have taken steps, lordship.
Respondent number 2, I have taken stress steps, Lordship. Meghalaya, Shillong, so I have taken stress steps.
So you can start it. You can start. Please go ahead.
Lordship. Uh, uh, Lordship, our case is otherwise, Lordship. Uh, It's filed by one Mr. Major Shailesh Nair. if I may take your lordship to paragraph 6, page 50. Uh, 50, running page 50. I may read. The deponent says that on 11 to 2004 at around 1600 hours, a police patrol vehicle led by ASI also had gone to village Saizong. As they were approaching the village, Kuki Revolutionary Army militants housed up in the community hall opened fire on the police party. The police party immediately retaliated, but it should have been owing to confusion, they withdrew. The party reached the company-based camp, ADP, at around 1830 hours and informed the company commander about the incident. PSIKA ASI had lodged as FIR, an FIR, it should have been, Dilai. At around 1900 hours, the company commandant of 19 Garhwal Rifles received information that a police party was fired upon in village Saizong by Kuki Revolutionary Army militants. The company commander at company operating base, KDP Bazaar, following the information, moved the column in vehicles and dismounted short of the village. The company commander immediately started advancing on foot and tried to skirt the village from east. As the column was approaching on the side of entrance of the village, they came under intense militant fire. Next paragraph will be important. The deponent begs to state that the troops of 11 Garhwal Rifles fired back while facing instant firing from the militant. The exchange of firing took place for some more time, after which the hostile fire ceased. A search operation was immediately launched and the bodies of 3 militants along with weapons were recovered. So our cases, lordship, they were not in our custody. And even the bodies were not claimed.
Page 50. Your lordship may see one thing in their affidavit at page 52, paragraph 10. There they have stated that this in particular incident took place in Saijang village. And as per a writ petition, the incident took place at Khonumpal village. So there is a huge distance between both the villages of about 70 kilometers. And the dead bodies also that was recovered from Bokajan police station. So these two incidents are not the same incident.
Lordship will just bear in mind, if the statement made by my friend has to be given some credence, why the bodies were not claimed? They knew the bodies were given the last rites under the police supervision. Nobody claimed the bodies. Now, that incident was of 2004 and they filed a writ petition in 2023. If at all, Lordship, those places are different, the best authority to say where would be the Bokazan police.
And also there is a difference in the timings. The affidavit states that the timing is 4 o'clock, 4 p.m. And in the writ petition, we have stated 11 a.m.
There are two FIR. One of the police report attack that was at court. That is right. Perhaps police are applying it again. There is a second. That is the second. Page 50. 50. আমার page 50 দুখন এফআইআর না প্রথমতে উপর দেখা যাচ্ছে আমি সেকেন্ড এফআইআর
Okay.
Annexure. It's 31. Yes. Uh, yes. Then there is a considerable delay. Your Lordship, considering the fact that my fundamental right has been violated. Immediately, I did not. In this regard, I may be allowed to assert certain decisions. Yes. Petition 2023.
I think 9/1/2023.
19.
The copy was served on 9/1.
May be allowed to go through certain.
I would just like to point out one more thing. I may be wrong. If your lordship will come to page 4 of the petition, page 4 of the petition, the parties. Lordship will see the age. Respondent number 1 is 30 years in 2023. That means she must have been married at the age of 10. And petitioner number 3 was not even born when the incident occurred. There may be some typographical error here, but
Might-
even otherwise, affidavit says the petitioner number 1, 34 years as on 23. That means must have been married at the age of 14 or 13.
Yeah. Hmm. Lordship, after Bihu.
Yes, right.
Obliged.
I'm hearing for respondent. The lordship, allow me to argue the matter some other day, lordship. Today, I'm not feeling well, lordship. Maybe after the Bihu, lordship.
Okay, my God, not it is finished.
Finished it.
my lord. My lord, recently, my lord, your lordship, the apex court has held in a case I have given the judgment in Darvinder Singh, my lord, case that, my lord, it has discussed, my lord, in that judgment, my lord, section 439 CRPC and as well as section 43D is discussed, my lord, and interpreted. The phraseology used in section 437 is shall be released on bail, whereas in section 443D shall not be released. So basically that is the thing. So UAPA Act, my lord, rigor of section 43D applies. And well, here your lordship will kindly see charge has already been framed. Charge is framed. That indicates that prima facie case against them is there. After charge sheet, investigating officer, after forming satisfaction that yes, prima facie case is there, charge sheet is submitted. And thereafter, on scrutiny of records, as well as after examining the charge sheet submitted by the IO, the courts, after hearing the both the sides, prosecution as well as defense, passes an order either framing of charge or discharging the accused. Now, in this case, my lord, the charge has been framed, and on 2 dates, my lord, witnesses were summoned, but subsequently, only one date we find. On 3/11/23, the scanned copy of the LCR has been sent to this honorable court, pursuant to an order of this honorable court. Now, after that, what is the development in the trial? I do not know, my lord.
That your lordship, there is a stay. from this honorable
Yes. So anyway, my lord, now, my lord, with all due respect, I submit, my lord, prima facie, again, so far, allegation against this Zakir Hussain is concerned, my lord, he is well, lord, alleged to have committed offence under section 18 of the, my lord, UAP Act. My lord, funding, he has paid, allegedly paid, my lord, 1,50,000 rupees to his brother-in-law, Zahidul. Zahidul is, my lord, his brother-in-law. So, my lord, this is a band of, they are members of band organization, and, my lord, prima facie cases are there against them. With all respect, I submit, my lord, this is a question of, my lord, security of the nation, my lord. I have objection to that, my lord, bail.
Lordship, may I submit few things, your lordship? Your lordship may kindly take up my bail application, your lordship. Bail number 3642, your lordship. The charge sheet, your lordship. Page 38, your lordship. Now, this case, so far as the accused Zakir Hussain is concerned, your lordship, the case started with a suspicion and the investigation ended in the suspicion, your lordship. There is no material as such, your lordship. Your lordship will kindly see page 38 for a moment of my petition, your lordship. What they have said, during this period, Zahidul Islam suspected to be received rupees 15 lakhs from Zakir Hussain. And then, your lordship, there is no debit transaction of rupees 1.5 lakhs found in the bank statement of Zakir Hussain, your lordship. Now, this is the finding in the charge sheet, your lordship, so far as the accused is concerned. Now, however, during analysis of account numbers of so-and-so Hamida Khatun, wife of Zakir Hussain, it is found that there has been 18 number of transactions so-and-so, April, the dates are there. Zahidul Islam suspected to be received rupees 1.5 lakh from Zakir Hussain and Hamida Khatun, but there is no withdrawal of cash of rupees 1.5 lakhs found in the bank statement of Hamida Khatun. However, rupees 50,000 has been transferred to account number so-and-so and 44,000 to account number so-and-so at least 15 days ahead of arrival of Zahidul Islam and Zakir Hussain at their residence at Nasabgarh, South Delhi. There is every possibility that Zakir Hussain and his wife Hamida Khatun might know the actual source of money wherefrom Zahidul Islam collected 1.5 lakhs from band organization. Now, your lordship will kindly see, after completion of the investigation, during the time of submission, your lordship, they have not been able to show to the honorable court, your lordship, bring on record anything, your lordship, we can show that where from this 1.5 lakhs came. Still in this stage of suspicion, your lordship will kindly note that, your lordship. Lordship.
No, your lordship will kindly see, there will have to be a prayer, your lordship, for this, your lordship, that further investigation may be, your lordship, always there is a prayer, your lordship, whenever there is investigation is going on, your lordship. That has not been there, and your lordship will knows very well, once charge sheet is filed, your lordship, trial started, your lordship, thereafter, your lordship, they will have to take permissions from the honorable court, your lordship. And that is not there, your lordship. And they have not said that investigation is still continuing, your lordship. Now, your lordship, apart from this suspicion, your lordship, I have gone through the statements of all the witnesses, your lordship, whose statements under 161 is recorded, your lordship, and I have found, your lordship, only one Amir Hussain, he mentions about that Zahidul stay in my house in Delhi. Apart from that, there is no material at all to bring these persons within the ambit of the allegations that has been brought against them, your lordship. And your lordship will kindly see, they are only, your lordship, it is, so far as section 43D5 is concerned, your lordship, it is not in respect of section 18, your lordship, section 13, your lordship, of UAPA. That rigor is not there. The learned court below, your lordship, mechanically frame charge, your lordship. This charge sheet is submitted under section 13 against this petitioner, your lordship, this accused. And the honorable learned court below, your lordship, frame charge under section 13, 10, 13, and 18, your lordship. That shows the, your lordship, non-application of mind by the learned court, and that is why we have put that to challenge, your lordship, before this honorable court, your lordship. That's, and the judgment, your lordship, the learned PP has, your lordship, produced, your lordship, recently, not recently, your lordship, few days back, your lordship, that judgment has also been distinguished by another bench of the Honorable Apex Court, your lordship, in Soma County Sen versus State of Maharashtra. This is judgment dated, your lordship. That is the very recent, your lordship, 2 or 3 days back this judgment has been given, lordship. Para 39 of that judgment, your lordship. This has been distinguished, your lordship. And it says, your lordship, the power of the constitutional courts to grant bail, your lordship, is always there, your lordship, looking at all aspects. Now, your lordship, if your lordship takes up the UAPA, your lordship, for a moment, your lordship will find, your lordship, so far as this petitioner is concerned, your lordship, there is nothing, your lordship, recovered from him, your lordship, not even a single document, your lordship. If your lordship go through the charge sheet, your lordship will find nothing has been recovered, your lordship. That is part of the charge sheet, your lordship. And documents and any other things, books, etc., these are recovered from some other person. That is at page 19, your lordship will get of my petition, your lordship. The materials and the property or documents that has been seized. Page 19 to page 22, your lordship. Now, your lordship, it takes up your lordship UAPA for a moment, your lordship. By no stretch of imagination, your lordship, these materials can bring any of the accused persons within the ambit of your lordship, section 15 of the UAPA Act, your lordship. And that has been settled by the Honorable Apex Court in number of judgments in recent days, your lordship. Now, your lordship will kindly see the definition of the terrorist act in UAPA Act, your lordship. Whoever does any act which intend to
Petition, yes. Zakir's petition, my lord. Yes. Yes. His number? 30. Yes, my lord. Serial number? Okay. Page 30 is something different. Yes, tax disclosed during investigation. It starts. 30, my lord, yes.
Your lordship, serial number 91 railway ticket, your lordship.
Page number, my lord.
26. Page 20.
Yes, my lord.
Lordship, Abdul Razak.
Under section 13 UAPA. Page 37. Yes, Zakir Hussain, Abdul Razak. During the analysis of account numbers, Zakir Hussain, it is found that there has been 17 numbers of transactions, which were from 24th of March 2023. Yes, during this period, Zahidul Islam, suspected to be received rupees 1.5 lakh from Zakir Hussain. There is no debit transaction of rupees 1.5 lakhs found in the bank statement of Zakir Hussain. Zakir Hussain's statements, I have examined. The statement is there. yes, sorry. However, during the analysis of account number so and so of Hamida Khatun, sister of Zakir Hussain, wife of Zakir Hussain, sorry, son of so and so, it is found that there has been 18 numbers of transactions, 7 debit transactions and 8 numbers of credit transactions with effect from 15th of March 2023 to 10th of April 2023. During 31st of March 2023 to 5th April 2023, Jahidul Islam suspected to be received cash rupees 1.5 lakhs from Zakir Hussain and Hamida Khatun, but there is no withdrawal cash rupees 1.5 lakhs found in the bank statement of Hamida Khatun. However, rupees 50,000 has been transferred to account number so and so and 44,000 to account number so and so at least 15 days ahead of the arrival of Zahidul Islam and Zakir Hussain at their residence of Nasafgarh, South Delhi. There is every possibility that Zakir Hussain and his wife Hamida Khatun might know the actual source of money, where from Zahidul Islam collected rupees 1.5 lakhs for a band organization. Even Zakir Hussain, son of so and so, son of Hyder Ali, also stated that Zahidul Islam collected this money from Zakir Hussain, son of Abdul Razak. Now, this 1.5 lakhs were seized from them,
Not from
while they were,
not from Zakir.
not from Zakir, yes, Zahidul. And Zahidul was taking shelter for some time in Delhi in the house of Zakir. So these things are there,
Now your lordship,
and the sister of Zahidul and wife of sister of Zahidul and wife of Zakir Hussain. Her statements may be sent. She has admitted that she paid rupees. So, 160, 170. Shashila. Yeah, this one.
only statement, your lordship, of statement of the accused, your lordship, that we have taken. But your lordship knows very well, after filing of the charge sheet, framing of charge, these statements has no value in the eye of law, your lordship. Neither that can be relied on by the prosecution, your lordship, for any purpose, your lordship, nor by the honorable courts, your lordship. It has no sanctity in the eye of law. Now your lordship will have to see, your lordship, to attract section 15, your lordship, the terrorist act, conspiracy to attract section 18. First, there will have to be ingredients of section 15, your lordship. And for section 18, there will have to be some active participation or active, your lordship, work by the activities by the accused person. Unless there is, that is not there, your lordship, the section 15 will nowhere will be attracted, your lordship. That is what, your lordship, in recent judgments, honorable apex courts have held, your lordship. 3 ingredients will have to be there, your lordship, and 3 at the same time will have to be present, your lordship. First the intent, then the means, then the effect, your lordship. These are the 3 basic ingredients for attracting section 15 of the UAP Act, as disclosed by the definition of terrorist act, your lordship. So far as other accused are concerned, also, your lordship, except being, your lordship, members of the band organization, there is nothing, your lordship, actively, nothing is attributed to them, your lordship, by which they can be said to be conspired, your lordship. And for that, probably, your lordship, section 18 will not come, your lordship. Section 13 is there, your lordship. 10 is there. At least at best it is a case of section 10, your lordship. And so far as section 10 is concerned, your lordship, it is not covered by section 43D5, your lordship. It is only under the offense is committed under chapter 4, then 43D5, your lordship, the restriction will come into play. Your lordship. And one major lacuna in this case from the side of the prosecution is that, your lordship, the prosecution sanction, your lordship, has not been, your lordship, taken, your lordship, as mandated by the act and the rule frame there under. Your lordship. The cognizance has been taken without prosecution sanction. Charge has been framed without prosecution sanction, your lordship. Now at a belated stage, when we challenge that framing of charge, your lordship, the government passed an order, your lordship, by which, your lordship, the sanction was granted, your lordship. But that sanction will not, your lordship, cure the irregularity which goes to the root of the issue, your lordship. In page 39, your lordship, for a moment, if your lordship takes up my petition, your lordship will find copy of the prosecution sanction order awaited, your lordship will find. That means, your lordship, on the date when this charge sheet has been filed, your lordship, the prosecution sanction order, the materials were submitted before the competent authority for getting prosecution sanction. Now, rule says, your lordship, within a stipulated period of time, this prosecution sanction will have to be granted. If they fails to do so, your lordship, a division bench of Kerala High Court has held that prosecution, the cognizance and the framing of charge will go immediately. Your lordship. Sanction was given, your lordship. It was after filing of the, your lordship, the criminal petition, your lordship. This Yes. Your lordship will get this, your lordship, in unlawful activities prevention, recommendation and sanction of prosecution rules 2008, your lordship. If your lordship takes up that judgment, your lordship. Lordship, para 22, your lordship will find that the materials that has been recovered from those two accused, your lordship. Para 22. Apart from these letters and statements, various literature, books, etc., have been referred to by the prosecution, which they claim to have recovered from the residence of KF and BZ. Similar, like the present case. Other three accused. These mainly involve writing on extreme left-wing ideology. Para 22, your lordship. These mainly involve writings on extreme left-wing ideology, including its application to India. Similar materials are also alleged to have been recovered from other accused persons as well. Recovery of different electronic communication devices like mobile phones, tablets, pen drives, and ancillary items is alleged to have been made. From these devices themselves, however, no evidence has been cited before us which would implicate AF and VZ in terrorist act and the other offences barring the letters on which emphasis has been laid by the agency. We have already referred to the letters which the law enforcement agency alleges to have recovered from the devices of other accused person in which there are references to AF and BZ. All detailed record has also been referred to for establishing location of the accused and also their inter-association. In our case, your lordship, even that those were not there, your lordship. In pursuance to judgment by court in Johur Ahmed Watali, this documents relied upon by the prosecution at this stage ought to prevail until outcome of this approved by other evidence. In case of Dr. Anand Teltumbe versus National Investigating Agency, allegations were similar in nature against the petitioner therein who had charged with the sections of the 1967 Act as has been done in case of AF and BZ except section 40. The Bombay High Court by a judgment delivered on 18 November 2002 had enlarged him on bail. The NIA petition for special leave of appeal number so-and-so against that judgment was dismissed by the coordinate bench of this court on so-and-so. As it would be evident from the analysis of the evidence cited by the NIA, the acts allegedly committed by the appellants can be categorized under the heads. The first is their association with a terrorist organization which the prosecution claims from the letters and witness statements, particulars of which we have been given above. But what we must conscious of while dealing with the prima facie worth of these statements and documents is that none of them have been seized or recovered from the appellants, but these recoveries are alleged to have been made from the co-accused. The second head of alleged offensive acts of the appellants is keeping literature, propagating violence and promoting overthrowing of a democratically elected government through armed struggle. But again, it is not the NIA's case that either of the two appellants is the order of the materials found from their residence as alleged. None of this literature has been specifically proscribed so as to constitute an offense. Just by keeping them, their thirdly, so far as AF is concerned, some materials point of handling of finances, but such finances as per materials to which the dealings are sought to be established so that the transaction was mainly for the purpose of litigation on behalf of it. It appears to us detained party person. The formation or association with a legal front or banned terrorist organization has also been attributed to AF in addition. The High Court, while analyzing each of this, then your lordship will kindly come to para 26. Finding in none of the materials which have been referred to by the prosecution, the act specified in to subclause A of section 15(1) of the 1967 Act can be attributed to the appellants. Nor there is any allegation against them which would attract subclause 3 of section 15(1) of the state statute. As regards the act specified in section 15(1)(b) thereof, some literature alleged to have been recovered from the appellant by themselves give hint of propagation of such activity. But there is nothing against the appellants to prima facie establish that they have indulged in the activities which would constitute overthrowing then public functionary by means of criminal force or the show of criminal force or attempts by appellants to do so. Neither there is any allegation against them of causing death of any public functionary or attempt to cause death of such functionary. Mere holding of certain literature through which violent acts may be propagated would not ipso facto attract the provision of section 15(1)(b) of the said act. Thus, prima facie, in our opinion, we cannot reasonably come to a finding that any case against the appellants under section 15(1)(b) of 1967 can held to be true, your lordship. Now, here is a case, your lordship, where except your lordship some documents, your lordship, some books, etc., Your Lordship. No material, no, nothing has been seized, Your Lordship. No, Your Lordship, arms and ammunition, Your Lordship, as required under the section 15(1)(15), Your Lordship. Nor they have actively participated in any act which causes death or anything, Your Lordship. Your Lordship, may kindly see section 15 again for a moment, Your Lordship. Whoever does any act with intent to threaten, likely to threaten the unity, integrity, security, or sovereignty of India, or with the intent to strike terror or likely to strike terror in the people or any section of the people in India in any foreign country, A, by using bombs, dynamites, and other explosive substances or inflammable substances, or firearms, or lethal weapons, or poisonous or noxious gases, and other chemicals, or by any other substance, whether biological, radioactive, nuclear, and otherwise of hazardous nature, or by any other means, whatever nature, to cause or likely to cause, these are the consequences, Your Lordship. Now the intent then means, Your Lordship. And even if, Your Lordship, by any other means, Your Lordship, that will have to be, Your Lordship, will have to be interpreted, Your Lordship, by applying the doctrine of ajus dem generis, Your Lordship. The prior words, the meaning given in the prior words will have to be considered, Your Lordship. That's how, Your Lordship, the Honorable Apex Court has interpreted things, Your Lordship. So, Your Lordship, on the face of it, in none of the cases, Your Lordship, in case of none of the petitioners, Your Lordship, these provisions can be attracted, Your Lordship. At best, it is a case, Your Lordship, of section 10 of UAP Act, Your Lordship. And in that case, Your Lordship, stringent provision of section 43D5 will not be attracted, Your Lordship, which learned public prosecutor is responsible. They may be members, Your Lordship. And so far as Zakir is concerned, that is not even their allegation, Your Lordship, that I am a member, Your Lordship. Now, even in the present case, Your Lordship, this has not been reported yet, Your Lordship, this judgment. We have downloaded it from the website of the Apex Court, Your Lordship. And this was dated, Your Lordship, 5/4/2024. Here, Your Lordship, another accused of that particular case, Your Lordship. Here, Your Lordship. Para 29, Your Lordship. There is a reference, Your Lordship. In the light of these materials, we shall have to examine the strength of prosecution to implicate the appellant in the offences specified under. Here, Your Lordship, it's more, Your Lordship, dangerous kind of activities attributed to 16, 17, 18, 18B, 20, 38, 39, 40 of the 67 Act. There is also allegation against her for the commission of offence under section 13 of the same statute, but that offence does not come under purview of the bail's restriction provision of section 43(5) of 1967 Act, and we shall deal with that accusation in the succeeding paragraphs of the judgment. The offence under chapter 4 of 1967 Act, with which the appellant has been charged with by the prosecution agency, mainly stem from commission of a terrorist act. Then this definition, Your Lordship. Then we are not concerned with the subsection 2 of the said provision in this appeal. There is no allegation of any act of the appellant constituting an offence within the scope of second statute of the same statute. Subsection 1 of section 15 refers to certain acts which would constitute terrorist act, but the first part of subsection 1 of section 15 cannot be read in isolation. In our reading, the said provision of the statute to qualify for being terrorist act, such act must be done with intent to threaten or likely to threaten the unity, integrity, security, economic security, sovereignty of India, or such act must be accompanied with an intent to strike terror or likely to strike terror in the people of any section of the people of India or in a foreign country. These are initial requirements to invoke section 51 of the 1967 Act. The legislature, however, has not left the nature of such act unspecified, and in subclause A, B, and C of the said subsection, the law stipulates the manner of commission of the act specified in first part of section 1 of section 15. if any offender attempts to commit any of the specified in section 51 to come within ambit of the expression terrorist act under 1967 legislation, action or intention to cause such act must be by those means which have been specified in clause A, B, C of the said provision. This is the line of reasoning broadly followed by the court in the case of Vernon in construing the applicability of said provision. Therefore, your lordship, these are interrelated, your lordship. We cannot look at these provisions, your lordship, isolatedly. A, B, and C. Intent, means, and effect. If both these three ingredients are present, then only a person can be brought within the ambit of section 15, your lordship. And here, your lordship will find that intent may be there, your lordship. But so far as the means and the effect is concerned, so far as these petitioners are concerned, there is nothing at all, your lordship, can be brought on record by the prosecution, your lordship. On the allegation of raising funds for a terrorist act forming part of charge under section 17 of the 1967 act, this is not required. This is because, your lordship, not 670. And then, your lordship, lordship, para 32 for a moment, your lordship. Lordship. And then para 39, your lordship, lordship. 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 Whoever does any act which intend to threaten or likely to threaten the unity, integrity, security, economic security, or sovereignty of India, or which intend to strike terror, or likely to strike terror in the people or any section of the people in India or in any foreign country. A. Lordship. Intent. Lordship. Intent. Lordship. Lordship. Or any section of it. Foreign country. Lordship. These are the intent. Intent. Lordship. Lordship. By using bombs, dynamite, or other explosive substances, or inflammable substances, or firearms, or other lethal weapons, or poisonous or noxious gases, or other chemicals, or by any other substances, whether biological, radioactive, nuclear, or otherwise, of a hazardous nature, or by any other means of whatever nature, to cause or likely to cause. Lordship. Then death or injuries to any person or persons, loss of or damage to or destruction of property, disruption of any supplies or services essential to the life of the community in India or in any foreign country, or damage to the monetary stability of India by way of production of smuggling, circulation of high quality counterfeit Indian paper currency coin or any other material, or damage or destruction of any property in India or in a foreign country used or intended to be used for the defense of India or in connection with any other purposes of the government of India, any state government or any of their agencies, or overalls by means of criminal force or by the show of criminal force or attempt to do so, or causes death of any public functionary or attempts to cause death of any public functionary, or detains, kidnaps, or abducts any person or threatens to kill or injure any such person or does any other act in order to compel the government of India, any state government or the government of a foreign country or an international or intergovernmental organization or any other person to do or abstain from doing any act or commit a terrorist or commits a terrorist act. This subsection, public functionary, high quality, and the terrorist that include which offense finally new. Lords. 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 Lordship. Lordship, this is your lordship will kindly first your lordship. This is not the prosecution case at all, your lordship. 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 ABC, your lordship. 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 Well organized, no doubt about that. Lordship. Lordship, that's the case, your lordship. Unless your lordship search indicates that this is actually the actual act that can be attributed to these people, your lordship. 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 The other three, your lordship. Lordship. Brought into play, your lordship. And in fact, your lordship will kindly see they actively participate, your lordship. Now, your lordship will kindly see in State versus Nolini, that's the case, your lordship, of the Rajiv Gandhi murder, Prime Minister, your lordship. Under TADA, your lordship, the Honorable Apex Court has held, your lordship. I don't know whether your lordship, that judgment, your lordship, but your lordship held that that act is not a terrorist act. Since three of the ingredients are at the same time not present, your lordship. I have not brought that judgment, the big judgment, your lordship. But in that particular case, your lordship, Apex Court has held that the killing of the Prime Minister, ex-Prime Minister, is not a terrorist act, since these three ingredients are not present together, your lordship. That's what your lordship, Apex Court has done. But so far as these petitioners are concerned, your lordship, so far as Zakir Hussain is concerned, from the son of Abdul Razzaq, there is no material at all, your lordship. And your lordship has seen, your lordship, even this Harshit says, your lordship, it is still in the realm of suspicion. He may have, your lordship. When others are concerned, your lordship, some materials are, no doubt, your lordship, some related to your lordship, PFI related materials are, whether that will ipso facto bring them within section 15 or not, your lordship, that's the issue before, probably in my humble submission, before this honorable court, your lordship. And your lordship will find that ultimately 1 year have already been elapsed, your lordship. And in all PFI related matters, only these 4 persons are now behind bar, except these 4, your lordship. All the other accused persons are granted bail. Not in this case, your lordship, in other PFI related cases, your lordship. Your lordship may always impose stringent conditions, your lordship, by which they will abide by that, your lordship. Ultimately, your lordship, even in cases like Bhima Koregaon, your lordship, where allegations are related to your lordship being member of CPI Maoist, a dreaded terrorist organization, your lordship, and working on behalf of them, your lordship, the Honorable Apex Court has interpreting these laws, your lordship, has granted bail, your lordship. And then, your lordship, in this particular case, comparing to that, your lordship, these are no materials, there is no materials at all, your lordship. Your lordship, if your lordship takes up the our seat again, your lordship will find page 19, your lordship, the materials that has been recovered from these people, your lordship. Para 19, page 19, your lordship. Saving passbook, your lordship, railway ticket, white paper, cash, 1,50,000. Then your lordship will page 22, your lordship will find the which can they are trying to say as incriminating materials, your lordship, these books. One book, namely RSS ke Upodjonok, Contractor Jonne ki Chudu Muslim or Horir Sorsa, Dolit Mukti Andolon, Saddam, Honorajjo. No doubt about that, your lordship, that being part of this organization which has been banned by the state, that cannot be accepted, your lordship. But will that, without any material, your lordship, bring them within the ambit of section 15 or not, your lordship? And your lordship, one line of judgment, your lordship. It is, your lordship, to 1994 SCC 76, your lordship. Para 8, your lordship. 1994 SCC page 76, your lordship. This is in SCC 76. Para 8, your lordship. This is related to Tada, your lordship, interpretation of Tada. 1994 SCC 79. One line only, your lordship. The act is a penal statute that it has been referring to Tada. Its provisions are drastic in that they provide minimum punishment and in certain cases enhanced punishment. Also, make confessional statements made to a police officer not below the rank of a superintendent of police admissible in evidence, and mandates raising of a rebuttable presumption on proof of facts stated in clause A to D of subsection 1 of section 21. Provision is also made in regard to the identification of accused who is not traced to photographs. There are some of the special provisions introduced in that act which have due to controlling the menace of terrorism. These provisions are a departure from the ordinary law, since the said law was found to be inadequate and not sufficiently effective to deal with a special class of offenders, including indulging in terrorist and disruptive activities. There can therefore no doubt that the legislature considered such crimes to be an aggravated nature which could not be checked or controlled under the ordinary law and enacted deterrent provisions to combat the same. The legislature therefore made a special provisions which can be in certain respects be said to be harsh, created a special form for speedy disposal of such cases, provided for raising of presumption of guilt, places extra restriction in regard to the release of offenders and make suitable changes in the now this act is like the one that has been referred to, your lordship, and here there is one statement, one observation by the effect that, your lordship, it says, your lordship, the in this stringent, when there is provisions of the penal statute that are stringent, your lordship, this will have to be interpreted in your lordship. That is the principle, your lordship knows it, your lordship. That is what, your lordship. Lordship, and then 39, your lordship, so where your lordship latest judgment relied on by learned public prosecutor has been distinguished. Your lordship. Now, ultimately, since it is a question of article liberty under of the citizen, your lordship, and they are behind bar for lordship, same one. Para 26, your lordship. Lordship. And also your lordship 29. And 36 also, your lordship. Here it says, your lordship, the manner in which stringent provisions of a statute ought to be interpreted has been laid down. In all the three authorities, observation of this court has been that court ought to carefully examine every case before making an assessment if the act would apply or not, your lordship. In that view of the Zakir Hussain, and other three also, your lordship, I have lordship.
One thing I beg to make submission. My lord, whether your lordship will go so deep into the matter, whether offense my lord. Yes. Yes. From that view, according to that view, my lord, he is entitled to it. Now, my lord, my submission is this. My lord, whether framing of charge is a final order. My lord, CRPC provides for alteration of charge at the fag end of the trial also. Now, my lord, after, my lord, my lord, it is admitted, my lord, there is nothing on record to show that he is not member of the band organization.
It is not there.
No,
Yes.
no, my lord. No, I am talking about Zahidul, my lord. Zahidul is a member. Zakir also. No, Zakir, yes. I am coming to Zakir, my lord. I am first. Yes, sir. And he gave shelter in him in Delhi. And they came together. So, my lord, as from that view of the matter, tomorrow after recording evidence, there may be evidence of offense under section 39 39 and 40 also, my lord. Those offences come also under chapter 6, for which, my lord, rigor of section 43D applies. Charge can be altered at the fag end of the trial also, my lord. This charge has been made only on the basis of prima facie case, my lord. Only on the basis of prima facie allegations. It is not that court will have to stick to the offense under section 18 or 10 or 9. Flexibility is always there till end of the trial, my lord. So that is why withhold respect submit, my lord. For the purpose of bail, all these submissions are not relevant. That is my humble submission, my lord. Tomorrow, after recording of evidence, my lord, offense under section 39 or 40 may be proved.
Lordship, can your lordship, based on certain presumptions, I can be detained for indefinite period, your lordship? Tomorrow there may be materials, your lordship. Your lordship is considering it on the basis of materials as is there as on today, your lordship. What may happen in future, that cannot be consideration of this honorable court, your lordship. And that itself shows that, your lordship, there is no material. It's virtual an admission on the part of the learned PP that as on that there is no material, your lordship. This is my humble submission. Lordship. Lordship.
My lord. Yes. That's why charge has been framed. My lord. I have given one judgment regarding, my lord, that, my lord, so far offense under section under the UAP Act is, my lord, bail is the exception, jail is the rule. That is the latest observation.
Lords.
My
Lords. Lords. Lords.